Welcome back to The Explainer. Today we are diving deep into federal pharmacy law with another round of practice questions. This is all designed to get you laser-focused and ready for the MPJE.
So if you're here, I'm guessing you're gearing up for your boards, and you already know how important it is to have this material down cold. But, this is about so much more than just passing an exam. The real question is, how do you take all these rules, all these regulations, and turn them from just facts in a textbook into a real framework you use to protect actual human lives every single day? Well, the answer comes down to one core concept: mastering your corresponding responsibility. That idea connects every single law we're about to talk about. All right, let's dive in. First up, we're jumping right into the heart of pharmacy law, the rules of engagement for handling controlled substances. So here's our first question, and it's a big one because it reflects a major shift in federal law. Let's say a patient or their doctor requests a partial fill of a Schedule II drug. How long does the pharmacy legally have to give them the rest of it? The answer is 30 days. That's from the date the prescription was originally written. And this is such a critical update. A lot of us were probably trained on the old 72-hour rule, right? But that only ever applied if the pharmacy was out of stock. The Comprehensive Addiction and Recovery Act, CARA, in 2016 totally changed the game. It introduced this 30-day window specifically for when a patient or a doctor asks for a partial fill, and the whole point was to help cut down on the number of unused leftover opioids sitting in people's medicine cabinet. All right, next, let's talk paperwork. You know it, you love it. It's the backbone of all accountability in pharmacy. So, which DEA form is the one you absolutely have to use for ordering and also for returning any Schedule II drugs? That would be the one and only DEA Form 222. It's right up there with other essential forms, like the 41 for getting rid of drugs and the 106 for reporting theft or loss. And, the evolution of the 222 form itself is a pretty cool snapshot of how our profession is modernizing. We went from those old-school carbon copy triplicate forms to a single sheet, and now to the fully electronic system, CSOS. Let's move on to refills. I can pretty much guarantee you will see a question about this. For a Schedule III or a Schedule IV drug, what's the absolute maximum number of refills a prescriber can put on one prescription?
The answer is 5, a maximum of 5 refills, and all of them have to be dispensed within 6 months of the date it was written. And just remember the big difference is, Schedule IIs, they get 0 refills, period. And for Schedule Vs, federal law is a bit looser, but a lot of states just apply the same C3 and C4 rules anyway. And as you know, you always have to follow whichever law is stricter. Okay, so knowing the rules for each drug schedule is fundamental. Now let's build on that and get into the next part of the pharmacist toolkit, decoding the scripts themselves. All right, here is a classic exam-style question for you. Which of the following is not a characteristic of a valid DEA number? The thing you really have to think about here is the number itself. Is it just a random string of numbers, or is there a hidden logic to it? Well, it turns out a valid DEA number is not random at all. It's got a built-in formula, and you can check it yourself. It's actually pretty easy. First, you add up the first, third, and fifth digits. Then you add up the second, fourth, and sixth digits and multiply that result by 2. Finally, just add your 2 results together. The very last digit of that final sum has to match the last digit of the DEA number. It's a quick, powerful little tool to spot a potential fake. Sticking with the theme of prescription validity, what are the absolute must-have pieces of information that have to be on a controlled substance script for it to be considered legal under federal law? So, according to federal law, a valid controlled script needs all of this: the date it was issued, the patient's full name and address, the prescriber's full name, address, and DEA number, the complete drug info, name, strength, dosage form, the quantity, the directions, and of course, the prescriber's signature. And here's a key tip for the exam. A patient's date of birth, super common, required by tons of state laws and insurance plans, but it is not a federal requirement. Now, let's zoom out from the nitty-gritty of a single prescription and look at the landmark laws that have really shaped the entire landscape of modern pharmacy practice. This next law had a massive
massive impact on the day-to-day workflow in community pharmacy. Which act created that whole new category of scheduled listed chemical products and put those tight restrictions on things like pseudoephedrine?
That would be the Combat Methamphetamine Epidemic Act of 2005. You'll see it as CMEA. It was a very direct response aimed at disrupting the illegal production of meth by controlling who could get their hands on the ingredients. The CMEA is what gave us those firm, federally mandated sales limits we all know. No more than 3.6 grams of pseudoephedrine per day, and no more than 9 grams in a 30-day period. And, of course, the Act also requires that every sale is recorded in a logbook and that you have to keep those records for at least 2 years. Now, for a law with a totally different goal, this one focused on sparking innovation. Which federal act gives special incentives to drug companies to get them to develop treatments for rare diseases that only affect small numbers of patients? The answer is the Orphan Drug Act of 1983. It basically acknowledged that without some kind of financial push, it just wouldn't make sense for companies to research these orphan drugs. So the act provides things like tax credits and a longer period of marketing exclusivity to make it a worthwhile investment. So here's the crucial point. All of these specific rules, these forms, these different acts, they are not just random items on a checklist you have to memorize. They all funnel down into one single thing: patient safety in practice, which of course brings us right back to our central theme. Let's put this all together in a scenario I'm sure you'll face at some point. A patient you've never seen before walks in. They hand you prescriptions for this classic red flag trio: high-dose OxyContin, Xanax, and promethazine with codeine syrup. They don't have a file with you, and they insist on paying cash. I mean, every single alarm bell for potential diversion is ringing loud and clear. So in that moment, what is your best, most professional, and most legally defensible course of action? Your duty here is crystal clear. You don't just automatically refuse it, and you certainly don't just fill it and ignore the signs. You have to exercise your professional judgment. That means picking up the phone, contacting the prescriber to verify the scripts, and discuss your concerns. And after that, you document every single step. That is what due diligence looks like in the real world. This entire process, this whole scenario, is the perfect definition of corresponding responsibility. It is your legal and your professional duty to do everything you can to ensure every single prescription was issued for a legitimate medical purpose by a doctor acting in the usual course of their professional practice. And let's end with the words that say it all, pulled straight from the Code of Federal Regulations. The prescriber has their responsibility, yes, but a corresponding responsibility rests with you, the pharmacist. You are not just an order filler. You are the final critical checkpoint for safety and for legality. Mastering that role is what makes you an essential, irreplaceable part of the healthcare system. It isn't just about knowing the rules. It's about understanding your profound responsibility to uphold them.